Okay, so welcome everyone. Bienvenue tout le monde. We are on live on Zoom tonight, but also on Facebook, or we're going to be in a few seconds, but I believe that we are as well. We have a lot of partners sharing this video tonight, and I really thank them all. So I will quote them again in the end, but we have Notre Affaire à tous, we have the European Greens, and we have Earth Thrive and a number of other organizations. So we're really happy also to have and to launch this huge European discussion with a lot of people tonight. So as you know, this is the second conference that we organize on the rights of nature in Europe. What do we want? We want to reach the recognition of the rights of nature in the EU. We have a long journey in front of us to do so, but we are more and more people every day fighting for the recognition of the rights of people. So just to let you know and to everyone about technical matters first. We are on Facebook live in English mostly. If you want to listen to French, si vous voulez écouter en français, vous pouvez nous rejoindre sur Zoom. Et je viens de partager le lien sur l'événement Facebook. Donc, vous pouvez sauter sur le Zoom pour pouvoir nous rejoindre et vous aurez accès à l'interprétation. Pour celles et ceux qui sont déjà sur le Zoom, vous avez un petit carré interprétation et vous pouvez cliquer sur la langue qui vous arrange le plus. So for the people who speak English, you can also, if it happens that some of our speakers speak French, you can also click on interpretation to listen to the French version or to the English version, sorry. So we have this French English interpretation for you tonight. I hope that you will enjoy it. So we are live on Zoom and Facebook. You are really able to ask questions along the conference. So you can put them in the chat on Zoom or in the chat on Facebook. And we have some people here with us who will make sure that we, with the speakers, get your questions and we will try to address them at the end of the presentations of our very special guests tonight, or as long as they are formulated, if the speakers see them during their speech and want to address them directly. So once again, welcome to everyone. Bienvenue à tout le monde. On est très heureux de vous accueillir pour cette grande conférence. Si vous voulez écouter en français, on vous invite à nous rejoindre sur Zoom.
I invite you to join us
if you want to
here on
stick
Zoom.
to English, you're welcome to stick on Facebook, especially if we have too many people. But I think for the moment, we are okay with the load of people on Zoom. So we'll keep on going like this. So we began this cycle of conference a few weeks ago with the support of other green MEPs, among which Anna de Parnay will also say a little word tonight. We're really happy. We're working to protect the climate, biodiversity, of course, and our planet, but also the rights of the people, and thus the rights of nature, which are a condition for the respect also of the rights of people and of social equality. That's a bit what we want to say tonight. And since the rights of nature are not recognized in the EU yet, but are flourishing everywhere around the world, we wanted to launch this broad European discussion with the most people that we can. So please, if you know people that who could be interested, share these conferences with them, invite them to the next ones, and it's gonna bring people together so that we, discuss and decide about this very important revolution that we have in front of us, because the rights of nature are a revolution, a political revolution, legal revolution, and also a philosophical revolution that we need alive in the European Union in order to protect our planet. I also have some good news for you today, because after our first conference on the rights of nature, we managed to vote a resolution on the 23rd of October on the EU framework to halt and reverse EU-driven deforestation in the world. In this resolution, we got a great first success for the rights of nature, because in its paragraph 79, the resolution states that the European Parliament believes that ancient and primary forests should be considered and protected as global commons, and that their ecosystems should be granted a legal status. So this was a first win, and this is also the issue of our conference tonight, to dig into what could be a legal status for nature and the ecosystems in the EU. But I have other good news to share with you. This morning in France, the Council of State, le Conseil d'État, took a great decision on a climate litigation case that was launched 2 years ago by the city of Grande-Sainte, and with the support also of the NGOs who launched l'affaire du siècle, the case of the century. And the Council of State this morning told the French state that now we have to consider climate goals and trajectories as binding, and not only as words, but as commitments that should be taken into action. And this joins the decision from the Dutch Supreme Court in the Netherlands. The Conseil d'État, the Council of State, is the highest administrative court in France. So what we see is that throughout the EU, the Supreme Courts, the highest courts of the European Union, are beginning to deal with the protection of nature as something that is really binding, and that the tribunals are pushing politicians, executives, and governments to really act in a concrete way. So that's something that, of course, we are really happy about. So that was the good news I wanted to share. There is another one, because yesterday night, on the request of the European Environmental and Social Committee, a study was published on the rights of nature, which is suggesting a new charter, a charter for the rights of nature, a European charter for the rights of nature. And this discussion in the European Environmental and Social Committee joins ours, and also joins the work that is currently done by the Council of Europe, all of these European institutions working together towards the recognition of environmental rights and the rights of nature. So I will end up with this short introduction. I hope that you are happy about these great news that are really big steps to me at that moment. And I will give the floor to Anna, Anna de Parnay, who is a French and German MEP, a Green MEP, head of the Biodiversity Campaign group in the European Parliament. So Anna, I give you the floor, and thank you for being here and organizing this with us.
Yes, thank you very much. Good evening, everyone. My name is Anna de Parnay-Grunberg. I'm a French-German member of the European Parliament. I'm a forester and environmental scientist, and I was active 10 years at the local level, at the local council from Stuttgart, and now I'm working in transport and in agriculture policy to tackle, or to try to tackle, with all the wonderful people you can see here, climate change, and to try to save our biodiversity, what the ground of our life. The COVID-19 crisis poses huge challenges for our society and for the whole global community. We know that, and the economic and social consequences are now really measurable now. We are not really able to see the full extent. It is already clear that we are going through a deep crisis, and we have damages to our society, but also we should see the chances of deep collective changing in our minds. For decades, scientists have been warning that the risk of pandemic is linked to the destruction of ecosystem all around the world, and the unhindered penetration of humans in the ecosystems and the untouched nature, and this extensive way we are using nature is a really, of course, all the topic of clear cutting of forest also are leading to a rapid extinction of species. And we see now that when this disbalance is coming, those so-called zoonoses, yes, this illness coming from animals, some wild animals are spraying to us and transmitted to us. So we are now in the turning point, because we are experiencing the climate crisis and this decline in biodiversity, but also this really narrow pandemic that shows us that it's linked to our all everyday life. And so if we want to preserve and protect our basis of life, we have to move away from this anthropocentric view and anthropocentric exploitation of natural resources towards a more biocentric perspective and a holistic view of the world as a whole ecosystem we are in. And so it's a high time to recognize the protection and the preservation of environment as a public interest. And so the rights of the population to live in healthy and ecological balanced environment is a fundamental right. You probably know the old saying, law and justice are not always the same. So we as a human being, we have an idea of what is right and what is wrong. And we give ourselves laws, and that should come as close as possible of these ideals and ideas of justice. And so that great steps that Marie told us that the international community and also some council and some justice instance are now really looking at the base of a right of nature that is so important for us. Conserving biological diversity in the long term and using it within the limit of its capacity can only succeed if all political, social and economic players make this a priority of their own. And so I'm really delighted that my colleague Marie Toussaint, in collaboration with all these NGOs and wonderful people and with our Green Biodiversity Working Group, is launching this series of webinars to look for new ways in which we can have positive impact of the protection of the environment, biodiversity, and so at the end, our survival as a human being on this planet through the meaning of right of natures. So thank you everybody to this interest in this debate. I'm very looking forward tonight the discussion and to have your point of view on that.
So thanks a lot, Anna. This was really inspiring as well, and it's really good to be all working together. And we are, with the Greens, of course, mobilized, but we will gather more and more MEPs also from other political groups to move in that direction and think over what would mean the rights of nature. We're really committed to that. And thank you a lot, Anna. So tonight we also have great speakers from all around the world to question the rights of nature and the legal status of the ecosystems. So I'm really happy to have with us tonight Laurent Fonbaustier, who is a law professor at the Paris-Saclay University. He worked on the chapter of the environment in France, and he is currently writing a book over also what could be a status for the non-human living being. So we're really happy to have you, Laurent Fonbaustier. We also have with us, and this is a great honor for us to have you with us, Felipe Calderon Valencia, who is coming from the Medellin University, specialized in environmental law, history of law, philosophy, human rights, and who will share with us experiences from Colombia, because Colombia is ahead of the EU in terms of the recognition of the rights of nature. So thank you also really much for being with us tonight from the other side of the ocean. We also have with us Kaarel Relve, who is a public interest lawyer working at Estonian Environmental Law Center, who is involved in environmental justice and access to justice in Eastern Europe, but also with the issues of the EU, because this is an EU law. And we're really happy also to have your insights in this very important discussion. And last but not least, we have with us Jessica Danuta, who is an Earth-centered law expert at the United Nations, who is also a consultant and speaker on the rights of nature. Currently, Jessica is very much involved in the rights of nature movement in the EU and in the world, and she is working to get the rights of nature recognized in the Netherlands. She will be talking to us about the case of the Wadden Sea, because we had there in the EU a beginning of recognition of the rights of nature. So we'll begin with you, Laurent Fonbaustier, to present us maybe, well, your analysis, your insights, and also, well, the work that you're currently running on this issue of the recognition of the legal status of the ecosystems and the rights of nature. I give you the floor.
Merci beaucoup, Marie. Merci.
Thank you very much, Marie. These are wonderful initiatives. I'm very happy with the news you just gave us. It's extremely encouraging, undoubtedly. But in terms of the subject that we are dealing with today, just modestly, because I know that there's more at play here, but some ways to spark discussion here we'll be looking at, thanks to our colleague from Latin America, we can see that the question here is posed, and it can be posed in different ways. You can look at it philosophically, or even from a civilian point of view. This will guide our discussion. I do not think where we see a big gap between humanity and nature, which is indeed a big part of our problem today. I'm dubious about whether or not we can have the same question, the same wording for all countries, where we see in certain civilizations, we have indigenous people, for example, that are quite present. I'm not saying that we won't have convergence points, no, but I do not think we can anticipate consequences in the way in which we are phrasing things. Another remark that could be interesting for specialists in law is that rights are not particularly fixed in a particular manner, and all the different arguments that we can have in terms of how we are personalize rights could be left to the wayside. We could be realistic here, but what law does is allow for us to represent general will, vulnerable people, or a minor. So if those who do not have an audible voice and cannot be properly addressed by law is something that we can fight against, because law is a series of tools that allow for us to make sense of things. I think this is something that we should indeed focus on. And we can be inventive. On the surface of the planet, this is something we can keep in mind going forward. Another thing that's important is that there are a number of questions here. When we go beyond a generous recognition of these statute on nature, there are a number of different rules at play here. We're aware of these questions. I'm sure that you actually did pose these in October during the webinar. How is nature represented? What elements here are at play? Will the animal world be represented? Will non-living organisms be represented? Will we be representing minerals or flora to the same degree as we represent great apes? Another question, and this is something that Marie mentioned too, we're speaking here about representatives who are representing people at bodies like the UN or the EU, for example. We have to think about how representation will take place. Now, a number of projects exist. Projects in which representative democracy in its traditional form is questioned. Because what we're speaking about here is ensuring that there's a space, giving voices at representative bodies. There are entities that were simply overlooked in representative democracy to this point. So I think that's important to mention now. And also we have to ask ourselves technical questions. What type of rights need to be precisely recognized? I believe there is a hierarchy of possible representation here. And perhaps, and this would be the last point, because I would rather leave this up to general debate, what can we expect? That's what we have to ask ourselves. And I believe Marie mentioned this case, but what about people who want to change the world? What can we expect from personalizing nature in terms of the tools, rather up against the tools that exist today that allow for us to protect the environment in itself, even though they're not efficient enough? Marie mentioned the statute of having commons. This allows for us to turn around the question of personalization and look at it differently and treat it differently. I believe that there's a question here that is posed because there are principles for protecting the environment. Administrative bodies understand this, but we have the problem here. Do we have something to actually win if we understand in France that particular flora could be represented, but other substances may not? I'm asking the question. I don't know. I'm not trying to be provocative. I'm simply asking the question. Now, in terms of animals, personalization allows for us to then move from the protection of biodiversity rather to focus on beings themselves. I know I clumsily referred to a few aspects there, but I'm looking forward to having a fruitful debate. Thank you very much.
Thank you so much, so Laurent Fonbaustier, for sharing this thought with us. Maybe we can also dig into those questions that you raised in our discussion, because raising questions is as much important as answering them. So this is really important. These are really important questions that you raised. And just maybe to remind everyone that we have English and French translation on the Zoom. So if you follow on Facebook and you want to have the interpretation, you can join us on the Zoom as well. And thank you so much, Laurent, for this very interesting presentation. As you said, we have the chance to have with us a professor at Medellin University, who is also a professor in Panthéon-Assas, actually, so who has one foot in each continent. But Felipe Calderon, Valencia, you are with us tonight, and we're lucky to have you. In Colombia, we've seen a lot of interesting development as regarding the rights of nature. We had the first decision in 2016 on the Atrato River, of which we heard from, at least here in the EU. And then a second one, which was quite important as well, on the request of 25 youth requiring their government to ask for the protection of climate change, but which ended up in the recognition of the rights of the Amazonian forests. And I believe that as an expert of what's happening in Colombia, also of the socio-economic battles that are led there, you can give us a really interesting insight into what we need to do in the EU and what we can learn from you and your experiences. So Felipe, I give you the floor.
Okay, thank you, Marie. So I want to share some kind of presentation. Shall we try? Okay, I think it can be because I am not a host, but okay. So I will just have a little analysis of what's happening in Colombia about the rights of nature issue. And I have to point out just 2 points. One is the development of the question in the jurisprudence of our constitutional court, just the decisions that this court have taken since 1992, when she just started to function in Colombia. And the second point is just about the activist protection issue, because Colombia, as you all know, it's a kind of dangerous country for people who try to protect rights of nature and the environment. So let's begin with the first element. It's just, I just want to talk about elements to understand rights of nature in Colombia. I have three points to touch. The first one is it's related to one period of time. This period, I call this period an ecological constitutional settlement, because it is just the beginning of something called the constitution, an ecological constitution in Colombia. This period engaged some decisions from the Constitutional Court in the way that she just recognized that we have a constitution like in parallel from our big constitution, and it is called an ecological constitution. It's just an interpretation, on a particular interpretation of the Constitution of Colombia, in the way that this interpretation could help to protect nature. So this is just one stage of our development. And the second one is what we call the stage of transition. It is between the first century of 20th, 21st century, and it is related mostly to the Constitution of Ecuador, because as you all know, I hope you know, that the 10th article of the Constitution of Ecuador recognized the rights of nature. So this had a big influence in our Constitutional Court, and since then the Constitutional Court began to recognize very shy some rights of nature, like rights, for example, to reach the social rule of law. In Colombia, we have a social rule of law, but now we're trying to pass to the next level, and that's what we call an environmental social rule of law. It's something like the Brazilian Constitution in the and in the Bolivian Constitution too. So, and in this particular stage of our constitutional development, we are trying to greening our constitutional procedure in order to have some actions to attack in some way the nature and the harms against nature. And for example, we have the case C467 from the 2016, where Constitutional Court recognized the animal's dignity as sentient beings. That's the category we use to analyze, for example, rivers, mountains, and paramus as subjects of rights, because at the beginning in Colombia we haven't that category. We just treat nature as goods, as public goods, and in this category we just have the right to exploit those goods in the common good of the community. Well, later on we have the final stage of our development on this issue of rights of nature, and it begins with the case that you already mentioned, Marie, and is the case T622 from the 2016 year, yes, and it recognized the legal rights to the Atrato River. And it is just one piece of the whole building, because after that we also recognize the rights of another river whose name Magdalena River, and at the same time we have also a very good decision, that is the case T36 from 2017, and it recognized superior constitutional protection to the Santurbans Paramus. That's a very hopeful decision, because here in Colombia we have a lot of freshwater springs, and we have also some corporations that want to exploit those paramus, but not with to extract water, but only to extract minerals like gold and quiver and all that. And finally, we have the case, it's a case of the Amazonian forest, rainforest, in which a constitutional court, it's the Supreme Court of Colombia, recognized a right of future generations to enjoy this Amazonian forest. Finally, just want to end my presentation talking about the importance of the environmental activist, because we all are related with the rights of nature, but we forgot very often that those rights of nature are just abstract things without the help of environmental activists and human rights defenders. That's quite my presentation, and I thank you to the invitation. Thank you.
Well, no, thank you, Laurent. I'm sure there are a lot of questions also to you on all these issues, but what I think really interesting in the Colombian case is this junction of social rights, environmental rights, rights of future generations, and the rights of nature, which I believe is really important to remind in France, since, as Laurent Fonbaustier said at the beginning, we tend, and I think it's the same in the EU, to say that nature and human are really separate, and that protecting nature would entail the philosophy of the Enlightenments and of human rights. So it's really interesting to see that in other countries, this is not the way this is apprehended. So thank you so much. I will now turn to Kaarel Relve from the Estonian Environmental Law Center. This is really important also to have this discussion throughout Europe. So we go to the other side of Europe compared to where I stand right now. And we will be really happy also to have, your expertise and analysis of the access to justice on environmental matters here in the EU, and how we could better improve the access to justice also with the rights of nature, or not. So Kaarel, I give you the floor.
Thank you very much for the invitation to the conference, and also for this wonderful introduction. It's an honor to speak here on behalf of Estonian Environmental Law Center. Recognizing of rights of nature is certainly an interesting philosophical question. However, my speech has more practical orientation. Over the years, our organization and I personally have participated in a number of international access to justice projects. Also, we often represent environmental NGOs and other members of the public in court disputes at the national level. In practice, there are, of course, many problems with access to justice. And the question I'm trying to answer today is the following. Would recognition of rights of ecosystems help solving these practical problems? Of course, it's not possible to speak all of the problems. In fact, I can speak only of one. And even of that problem, I can discuss it only in an abstract manner. I should emphasize that in reality, the problems of access to justice are very country specific for reasons that I can't go into. So it doesn't really make much sense to speak of them in abstract sense, but I think for the purposes of this conference, we can't go too much into the technical details. So what is the issue? The issue is burden of proof. To put it in simple terms, if you bring an action, you have to make a claim. And burden of proof defines who and to what extent has to prove or disprove the facts relevant to the claim. The rules of burden of proof differ, of course, from country to country. and also it depends on the subject matter. It tends to be different, for instance, in criminal matters. And to make a generalization, and this is of course a simplification, one could say that traditionally, the person who makes the claim has to prove the facts, and to such a degree that a reasonable person, such as a judge, would consider the evidence adequate to reach the conclusion that supports the claim. And let's consider the following example. Imagine a private energy company who wishes to build an offshore wind farm. The government has to decide whether the project can go ahead. And often we have a nature conservation organization who is worried about the project, about the ecological impacts of the project. In their eyes, this project should be stopped. And it's evident, of course, that the building of the wind farm would change the environment. However, it's much less clear whether this change should be is something that we should avoid. And in traditional sense, the nature conservation organization has this huge hurdle or task to prove that this change is such that it outweighs the benefits of the project. And this is very significant because especially if you talk about marine environment, then we often don't have enough data, enough information about them. Also, we don't fully understand all the causal relationships. And finally, it's not clear what value the ecosystem has. It may be evident that the ecosystem will be damaged, but much less clear whether it will impact also things that we clearly value, such as commercially important fish species. Now, the scenario just outlined is not actually realistic for the EU, because in EU, in such cases, there is already a modification to the burden of proof. I think all commercially viable wind farms have to undergo some sort of environmental assessment before they can be approved. And this essentially means that the developer or the public authority has to provide some evidence that this project will not have a serious environmental impact. However, in practice, these reports tend to be rather vague. Sometimes, and they don't give much confidence about changes in nature. And sometimes it may be by design, because if you look too closely, you may find something that is worth protecting. So it's better not to look too closely. But more often, I think it's just not unintentional. It's just the expert who has to make the assessment also faces the same problems, that there isn't enough baseline data, there are knowledge gaps, and there is not enough time to make a detailed study. So in practice, at least in EU, the environmental organization has to prove that there are some consequences of the projects which should lead to modification or even prohibition of the project, despite the official report claiming otherwise. And proving this is quite difficult. It's not sufficient, for instance, to say that, oh, this report is too ambiguous, or there are some contradiction, or something should have been studied in more detail. Actually, you have to prove evidence that the conclusions of the report are wrong, and this is very difficult for the reasons I outlined before. So what impact would recognition of rights of ecosystems have on this particular problem? And here I'm sorry to disappoint, I think, many viewers, but from a practical viewpoint, I'm afraid just the recognition of right of ecosystems would change very little. The impact would be close to zero. It seems to me that non-lawyers sometimes think that if you give something rights, then it automatically solves the problems. But this is obviously not the case. For instance, I was born in Soviet Union, and Article 50 of the Constitution of the Soviet Union granted freedom of speech. In reality, of course, it wasn't a full freedom of speech. Or even if we speak about democracies, not some communist regimes or dictatorships where the rights are just pieces of paper, then even in democratic countries, you have rights which cannot really fully be enforced. An example would be the right to health or clean environment. Most constitutions recognize this right to an extent, but you can't really enforce it in many instances because it's unclear what kind of environment this right guarantees. So it's difficult to enforce it. So, and what I want to say is that in practice, the right has to be made operational by much more precise rules. And it depends on these rules, whether the problems of access to justice will be solved or not. To give another perspective to this, then actually I think that the burden of proof might be an exception, because the impact of recognizing the rights, the direct impact is not entirely zero, because you have also this court activism. It is possible, quite possible, that the judiciary will apply the law creatively, and in some cases at least where the law is ambiguous. And because the burden of proof rules emerge from the court practice, then it's easier for the court to change this view. However, not too much hope should be placed on judges. In general, judges are conservative. Maybe Felipe is an exception here. And also in civil law tradition, the court is really not in a position to make these precise rules. The idea of separation of powers means that the court has to apply the rules, not to create them. So they cannot define the rules, precise substantive rules, at least they shouldn't. And also they shouldn't make the decisions instead of the administration. So Marie just reminded me that there are little time left, so I jump to the conclusion. What I want to say is that the direct impact of recognition of rights is not great, because rights need to be defined by precise rules. But it's this recognition of the rights creates the political climate and perhaps the shift in perception which allows to define these specific rules in a manner that helps to protect ecosystems. And one example of this is the Habitats Directive and the interpretation of the Court of Law, European Court of Justice, in their practice they have reversed the burden of proof. But this topic will be covered by the next presentation, so I won't go into details, but I want to end this presentation this optimistic note that it is actually possible to change also access to justice rules by the court practice. Thank you very much.
Thank you, Kaarel. Thank you so much. I hear my echo. I don't know if that's normal. No. Okay. Yeah. Thank you, Kaarel, so much, because it's important also to have the concrete aspect and you know what's happening on the ground when you are there defending the ecosystems, and that was really important also to have this practical, I would say, vision of it, and also to point out that sometimes we have some rights and duties that are written into our law, but which doesn't mean that right away they are applied. And this is also something that we need to fight a lot in favor of. And at the EU level, what we see is that a lot of laws are not respected, especially when it comes to environmental protection. So we regularly have, alarms rung by the European Commission because member states are not protecting the Natura 2000 areas or the air quality directives or other directives that protect the environment. So in the EU also, and not only in your country at the URSS time, Soviet time, we still need to be really vigilant as parliamentarians, but also as citizens and as judges. I believe that joins the tribunal discussion to ensure that those laws, rights and duties are really ensured. So now I turn to Jessica Denuten, who is an expert of hearth-centered law. This is something that maybe you can explain also to our audience tonight, but you also have a very interesting experience with a UNESCO World Heritage Site in the Netherlands, which is a quite unique area of biodiversity and also carbon storage. which was protected through a campaign for the rights of the sea. And I believe that the initiative was even adopted and then blocked. So maybe you can tell us a bit about how this campaign is going on, what's happening, and also what are the concrete implications of this recognition of the rights of the Wadden Sea. So Jessica, I give the floor to you. Thank you.
Yes, thank you, Marie, and good evening to everyone. It's an honor to speak on behalf of the Netherlands, and especially with these distinguished speakers tonight. So today I will speak about the two examples of how we envisage the manifestation of rights of nature here in the Netherlands. And I will first speak about the Waddenzee and also about the River de Maas, because we are launching a new campaign to grant legal status to River de Maas as well. So regarding the Waddenzee, this is, as Marie mentioned, this is a UNESCO World Heritage Site in the northern part of the Netherlands. It's actually a really unique area. It's one of the largest tidal regions in the world. And it's also very important for biodiversity and carbon storage and all sorts of other ecological functions. So hence its recognition as a UNESCO World Heritage Site in 2009. Now, actually in regard to the responsibilities of the Waddenzee, it's been a bit unclear because there's lots of organizations involved in its day-to-day management, be those NGOs, but also various parts of the government. And this has actually led to quite a complex and chaotic situation where the roles are not clearly defined. And in the meanwhile, the Waddenzee is still facing threats from sand and shell winning, but also fisheries and all sorts of activities that put pressure on the biodiversity and all the other ecological functions of this area. So this is why the Dutch government published a new plan for this area in 2019. Where they appointed 3 executive bodies overlooking the management of this area. And now I will talk a little bit about one of those executive bodies called the Beheerautoriteit Waddenzee, which is roughly translated as Management Authority Waddenzee, which weighs up the different interests of nature, tourism, fisheries, and residents in the area. Now, this authority was appointed in 2019, but is solely comprised of individuals of the government. And I think, you know, I just hinted at it with my fingers, but I think in terms of the language that we've used, the management of this area, it manifests as a very anthropocentric and I would argue traditional way of managing or looking after the well-being of this area. Shortly after, the municipality of Northeast Friesland adopted a motion calling for the recognition of the special rights of this area due to its uniqueness, and it actually called for a different and unique form of protection. And in this regard, they also called for an independent authority, like the one I've just mentioned, but rather than it being compromised just of government of individuals, we wanted it to be compromised of all sorts of representation of society. So that would be residents nearby the Waddenzee, but also fishermen and local governance especially. Now in 2020, I unfortunately do not have many updates in this regard. This motion was adopted last year, but together with colleagues, we are looking at how we can ensure legal status for this very unique area anyways. And especially my colleagues Jan van de Veenes and Tineke Lamboy, who had published an article last year calling for the special recognition of this area. And we are trying to spark public debate on this matter. Now, the second case I want to present to you tonight is the River de Maas, which is actually a river that originates in France, and it runs through Belgium and the Netherlands, and it ends up in the North Sea. Now, this is a beautiful river, but also it's been heavily polluted like many rivers around the world. And that is not just plastic soup, but it's also toxic chemicals from agriculture that are drifting in this river. And we have just launched a campaign to get this river's legal status recognized as well. And in that sense, we are trying to build on the emerging practice of legal status for rivers around the world. So that's New Zealand, but also Colombia and Bangladesh and all the developments that are happening right now. And I think especially here, I want to point out that we are also building on the European conversations in regard to rights of nature in this regard. And the way we are trying to envisage this is by creating a bottom-up movement. So we are engaging citizens, we are publishing articles and speaking to everyday citizens on how this approach could change and shift paradigms. Now, one concrete action I can tell you now, which got approved yesterday actually, is that next year we are going to launch a traineeship for youth, for young students, to help us co-develop ideas for the recognition of rights for the mass. And we are going to educate these students on the rights of nature. And I think personally, I'm really excited and happy with this movement because I think the youth is, has a vital role to play in advancing rights of nature. And especially if we look at young people, we can see that there's a shift in regard to paradigm of nature happening. And I think rights of nature taps into just that. Now, in conclusion, in this short speech, I think rights of nature is increasingly becoming popular in Europe. In Spain and Sweden and the Netherlands, we have talks on the rights of nature now. And I'm hoping at least that the Netherlands could become a front player in this field by recognizing rights for this river and also for the Waddenzee. And, even if it's just a shift of paradigm regarding nature in the Netherlands, because I think that's very important. And in this regard, we are building on the various examples of rights for water entities and rivers here around the world as presented by my fellow speakers. And I'm certainly hoping that we can soon manifest this concept in Europe. So thank you very much. And I'm looking forward to our discussion tonight.
Thank you so much. Thank you so much. That's really, really interesting. So I'm really happy to hear about that, Jessica. And also tonight we have a lot of men speaking, but also we know that rights of nature, it's often women behind. So it was good also to have one woman as a speaker, but I just point that out, as long as one goes. We've had a first question by the public that maybe I can ask, or is that fine, Philippine? Is that already good? Because we have also among our public someone that I did not expect to speak, but I feel like they have a lot to tell us also from the NGO Nigerian Rivers, who are holding a conference in the coming days. So I was thinking that it might be nice also to hear from them, and then I'll switch to the questions of the public, but maybe also if the speakers want to react to what another said, that can be something also that we open because we still have a bit of time. So Nigerian Rivers, are you around?
Yeah, can you hear me?
Yes, we can hear you. We cannot see you, I think. It would be better if we saw you.
They're having some technical issues with the video.
Okay.
But you can hear me very well?
Well, that's fine. Okay, let's go. It's a bit harder for interpretation though. So if you speak slowly, it's gonna be fine.
Yeah, congratulations for this second round of your meeting.
Thank you.
I'm happy to be a part of this historic meeting, and also to inform you we are making progress here in Nigeria, in Africa. By 30th of this November in Abuja, we'll be hosting the first national dialogue on rights of nature. It's being organized at the federal government of Nigeria in partnership with UNDP and Earth Law Center in the United States. And we hope we join in this meeting to see that right of nature takes its root in Africa through Nigeria. Thank you very much.
Well, thank you. It's really good to know that this trend, this wave, is going on throughout the world. And it was really nice to have you on board also. So we're really happy. Thank you for your testimony. So I'll now jump to a first question by the audience, and then maybe, yeah, any one of the speakers who wish to talk, you can go ahead, and then we'll get back to the questions from the public if you're okay. So I got one question that can be addressed to everyone at the same time. How would rights of nature affect private property or private stakeholders exploiting natural resources such as water, farmland, or fishes? So is there anyone among you who wish to react first to this question, which is quite relevant one, actually? Private property and natural rights. Laurent, yes, of course.
Yeah.
Oh, Felipe.
Can I
Felipe, go ahead, and then Laurent, it's all fine.
Yeah. For instance, in Colombia, we have that first stage of our development in which we have a great conception about the property on nature. We just saw nature as property, and that's normal because we are all in some way des enfants de Napoleon. We are all kids from Napoleonic legislation and civil code, and that's the way we think right now. But we have to evolve because as you see, you know, like the United Nations are right now trying to solve this problem with corporations because they trying to do something like a treaty, but a really good one. And this treaty is trying to engage corporations with this rights of nature issue in order to help, you know, like all the industry and corporations to help to enforce or endorse environmental rights, just to change the way we see the world since the 19th century. I think it's quite my opinion.
Laurent?
Oui, merci. Merci beaucoup.
Yes, thank you. Just very briefly. We have a theory that's developing right now in a number of different case law jurisprudences or in legislation at a European level, and that's the ecological law and the right to property. This could be looking at aspects not just from the nature point of view, but from the historical point of view, looking at the right to liberty or any liberal laws of that. These rights, property rights, can only be implemented if they respect ecological aspects, if they are in line with ecological standards, as long as they respect nature, the environment in which they're in. It was good to make reference to Napoleon, but this civil code is sacrosanct. The main subject today is to ensure that we have property rights in this community. There are a number of different projects on this right now, which will allow for us to better conciliate things, but right now it needs to be relative. Thank you.
Yeah, Jessica wants to add something. I also have questions for you, Jessica, but go ahead. It's really interesting.
I will answer very briefly, but whilst I completely agree with my fellow colleagues on that we should evolve basically from the rights of nature and the idea of property rights, I would like, well, I didn't have time in my presentation to talk about it, but I'm currently engaging in a study to see if we could use property rights and sort of enshrine rights of nature in it still. Because from a very practical and realistic point of view, right now, for example, in the Netherlands, it would be quite difficult to implement the rights of nature straight away. So we are looking from property rights if we could implement the theory and the principles of rights of nature into that. And how we are envisaging that is, for example, by setting up a declaration between the landowners and the land itself, whereby we try to focus the shift and create a relationship that is not based on dominance, but on mutual respect. So I just wanted to add that as something to explore, perhaps.
Yeah, I think Anna wants to jump in as well.
Oui, c'est un concept qui est très intéressant puisque
Yes, interesting concept, because in Germany, even if law is very close to this right of property, but there is a passage in the German constitution that's important for all of us here, and that is that the constitution, or rather property forces a number of obligations on people. We're seeing now in many states in Germany that all economic activity has to be to the public good, or in service to the public goods. Right now, we're trying to have an economy based on the commons. We're seeing it in Austria. We're seeing that there is an obligation in terms of property. And of course, you have to respect living creatures, Mother Earth, all of that. There are people now who are using this passage from the German constitution that was a bit overlooked the past few years, and people are bringing this to the fore again because it's interesting in this particular struggle. Thank you.
Kaarel, do you want to react to that question? Or we have got a lot of questions that are arriving right now, so we'll have other issues to discuss. But if you want to react to this one, which is
just a quick comment.
Yeah,
of course, recognizing rights of nature would have a great impact on property rights. At the moment, in practice, the property rights are more often, well, not more often, but often used for the protection of environment, because in traditional understanding, you need to show a connection, a personal connection to a problem. And it's difficult to show that damaging of ecosystems has personal connection, and one way to do this is through ownership of land. So it's a classical example where the property right is used for the protection of environment, and it's a very interesting question to what extent the property right includes actually ecological value of the land. And to a certain extent, courts recognize it, but in other areas it's vague. But if we recognize the rights of nature, it's clear that it will have great implications of right of property. Thank
you. Yeah. I believe we have both sides, right? We have the side where the rights of nature, of course, come and bousculer, shake the property rights as elaborated for a few centuries, but we can also link them with the rights of nature, which would help creating a new framework, but which also would help, passing through the bridge and bring everyone with us if we take that direction. So that's quite interesting. We've had a lot of questions coming up, so I'm sorry because I'm not sure I will be able to ask every one of them, but we have a series on very concrete questions on how to implement the rights of nature in the EU. So I will just raise a few of them, and then we can go again in the round of speakers to get your opinion and analysis and answers to those questions. Maybe the first one, which was raised, is asking, should the rights of the environment in the EU be implemented through the expansion of existing EU directives, such as the EU Habitat Directive, the EIA Directive, or other directive, or should they be tackled separately? Which is a pretty good question. Do we need a brand new treaty? Do we need a new framework? Do we need to change a lot of directives, including the ARIS directive, by the way? So that's something that, yeah, it could be interesting to have your point of view on, your opinion on. And we also have a very concrete question again about the role that could play the European Environmental Agency. Could we consider this agency, which worked a lot for the protection of the environment, as the guardian of nature in the EU? And I would expand that because I'm wondering whether we would need an ombudsman or ombudswoman for nature in the EU, and does it need to be linked with the actual ombudswoman or separated? So this is also something that we can discuss. So maybe with these two concrete first ones, which are actually huge questions. So I don't know if someone wants to jump in and begin with this answer. Laurent, I feel like you can want to go in. Should you? And if people don't forget that you have interpretation. I guess that if you're still here, it's because you know, but still.
Not necessarily. On the subject of the ombudsman, or on our subject, or a different subject? On the institutions of the EU, could that be? Okay. It's true that there's tradition in a number of countries, I'm thinking of France here naturally, to implement a lot of administrative authority in an independent nature. What's important or interesting in having an ombudsman is something that actually also makes me think of particular prosecutors that exist in criminal law. What we have to ensure is that the people who have these vigilant missions, so to say, have to be independent. That's something that we know is difficult in European law, but also in many democracies, where we have conflicts of interest. They should be allowed to have a number of powers, but there should be indeed an ability for them to call the alarm, sound the alarm for any types of particular crises, be that pollution or anything, or different things like that. We have to give them the means. We can't simply be content with having an institution in itself. But no, we need to have proper logistical means, financial means, and human resources indeed to ensure that this can happen. I think to have an environmental ombudsman is a very good idea, just to add that towards the end. Thank you.
Yeah, there was an idea like that. Who wants to jump in?
Maybe a comment.
Yeah, go ahead.
I personally can't imagine that rights of nature could be protected through the existing directives. Only maybe in case of habitats directives and indirect manner. Currently, the habitats directive only goes so far and says that ecosystem and habitats are common natural heritage of the Union. Nothing even about the intrinsic value of them. I'm not speaking of the rights. And the other directives are completely anthropocentric. So actually what we could do is to recognize the rights of ecosystems in some political level and then maybe expand the scope of the habitats directive or introduce similar legislation. Or the other way to do is to have a completely new framework. I'm not sure, it may even require changing the fundamental treaties of the European Union to recognize this right fully.
Yeah, I do believe so as well. Jessica.
Yes, maybe to bring this discussion to a whole other level, the international level. Well, we have just finished a campaign with fellow NGOs, with Earth Advocacy Youth, youth organization I have co-founded, to include the rights of nature in the Convention on Biological Diversity. So this is an international treaty, but I just wanted to point that out in addition to what Kaarel said, because the Convention on Biological Diversity in its post-2020 framework has become the first international environmental treaty to advance the rights of nature. So I think there could be a role in that regard in order to advance, the discussions and making rights of nature mainstream in a sense. But I do agree with Kaarel that it would be best if we come up with a new framework for the rights of nature, especially in Europe.
Nobody has answered yet on the role of the Environmental European Agency. So I don't know if Anna, you have an idea on that, or if you want to answer all the questions on how do we concretely do something.
I actually didn't really have a thought about the implication. Of course, we can have an ombudsman, but we really have to think what its implication. And we have so much ombudsman there really without power. and they can point out the problems we have, but we already know them. And so I'm really thinking about, for example, strengthening Natura 2000 or FHH, such a kind of really concrete manner we have, for example, to protect forests, as we've seen in Poland. But let's have a think about that. I'm not already done in my head with this idea. Thank you for reaching it out.
No, it's fine. Felipe, do you want to have a talk here?
No, just one thing is about the procedure. Everyone talks about substantive law, rights, but nobody talks about the procedure. I think European directives are full of things about procedure and ways to respond to some threats against nature and harm, environmental harm. But even though the main thing is to give power to some authorities, I think, as we do in Colombia, because we have some kind of general attorney who tries to push all the employees and the how do you call that, public servants, in order to enforce laws that protects nature and environment. That's what we do in Colombia. But even that way, and powerful as it seems, I think it's still very weak. So I think I'm with Kaarel. We have to change a lot of things, but fully change a whole makeover, because we are like stuck in the past, and we see property and environment as a thing, and not as a living being.
Yeah. You know, sometimes people are saying, let's not change the law, keep with the current law, because we are anyway unable to implement it, to apply it. So let's focus first on the way we implement it. But at the same time, you want to say, but we're stuck in a 20th century kind of law. So even if we implemented it, we wouldn't be able to protect the environment, and the environmental crisis is accelerating. So if you stick with a law from the past, then you won't be able to challenge anything. And also changing the law can help actually implementing, because we have, as you pointed out, so many different directives with so many different procedures that we also need to simplify the way we protect nature. There is also something that can be precised. Yeah, so I saw Felipe raising his hand. I just want to add another question that I had from the public. And then I also suggest that we go with your last remarks before we close it, but we have a bit of time, so you can also take your time. I see Anna, you're going, right? Thank you, Anna, for being with us. But yeah, we can move to the end of this conference, I believe. So just the last question, and I add that you don't have to answer it if you don't want, but it's just one question that were raised, saying we're talking about the EU level, which is broad level. I talked a bit before about the global commons, which is a global level, but rights of nature are also a lot about local communities and local ecosystems. So, how do we articulate this? So yeah, so Felipe, maybe if you want to react first to everything that has been said, and then we do this last round, not first, last, and we can close this conference. Felipe, go ahead.
No, just one thing, little thing, is that if we have a well done and structured procedure, we can challenge some laws and directives and stuff in order to green those, to paint in green the ancient or and the old laws that we have. That's the way we do in Colombia. We have a constitutional court, and then the constitutional court can help people and citizenship to greening, like slowly our legislation. So if we have a good procedure, we can change things very quickly or slow, but deeply.
Who wants to take the floor? It's as you wish, Jessica, maybe.
Sorry, just for my understanding, is this a closing argument that we are presenting?
Yeah, I was suggesting that you can rebound, but also let's go to the closing. But we have a bit of time, so if you want to rebound again after, you can.
Yes, I think, well, as I just mentioned, I'm currently engaging in studies regarding current property rights to see if we could enshrine rights of nature in there as well. Because whilst I agree that personally, I would very much like a European framework to be set up on the rights of nature. And well, if I'm speaking for the Netherlands, I would love the legal status of our precious nature entities to be recognized. I'm also very practical and realistic. And I think we should look at the current laws as well and see what opportunities we could have there as well to challenge anthropocentric foundations. So, well, I'm very excited and I really like the discussions tonight. And I saw one question regarding the Maas River as well in regard to the coordination between France, Belgium and the Netherlands. Well, the focus of our campaign right now is on the Netherlands, but I'm very much open to any suggestions and people from France and Belgium who would like to work together with us for the Maas. And building on the last question, I think local communities can play a really big role in this regard. And that's exactly what we are trying to envisage here in the Netherlands by creating a bottom-up movement. So thank you, Marie.
Well, no, thank you. This is really, really good to have everyone so motivated. So, yeah, Laurent.
Merci beaucoup. Juste deux mots peut-être pour
dire. Thank you very much. Just to say that I'm very much touched by what Felipe has been saying, because it's very interesting to look at Europe turning towards places or towards petri dishes that are showing some very inventive approaches in terms of rights. This is something very important for us. I said it touched me, what Jessica said too, because I think we can think at a European level, but we also need to think that international law offers interesting, efficient situations based on cross-border conventions. When we manage a common good, sometimes it's better and more practical to have 2 or 3 people who have a common interest over a particular resource. I think this is better because they tend to act more efficiently, because once it's at an international level, there's a different perspective. So it's important to think about the different stages of protection. Moving from the conceptual, general thinking to concrete areas where it actually works well. I think it's good if we identify a common good, and then we can then look at how it can be protected and looking at conventions of laws that can be applied. That could be the best way to go about it. And I want to say thank you once again. Thank you very much.
Thank you. We have a lot of leads, don't we? We would need like 10 other conferences like this to be able to dig into all the questions. And I want to reassure all the participants who are sending questions, we will note them and keep them for the next conference, but also to have this discussion alive. So we will try to find a way to have this discussion going on, and also with you, with the participation of everyone. So don't worry, you can keep on sending your questions, and until we close it, we will note them and keep them for later, but we will keep them for sure. Kaarel?
Yes, I think the question was that what is the role of the local communities in ecosystem rights? I think they certainly will have an important role, but I would like to highlight another aspect that maybe I'm too much focused on what's going on in Europe. But in my opinion, in Europe, we have the recognition of the value of nature as an economic side of the nature, and also the ecological side through nature protection. But there are other two areas which are clearly have to be protected, and this is the cultural value of nature and also the social value of nature. And sometimes these work in harmony, but they can be also in conflict. For a local community, the immediate nature can be of great value, but they don't necessarily coincide with ecosystem values. So it is important not to forget this social aspect, otherwise it will create conflicts. But as a closing remark, I think the idea of rights of nature is very radical for Europe, and I'm very happy that you organized this conference and there are such discussions. But perhaps it's more realistic to approach it step by step, and in the first step in real law speak more of values and less of rights, because values you can plug into the existing system quite easily, while rights I think at least need redefining of the whole framework. But of course, it's just a small step in between. But thank you very much for the invitation and for this great discussion.
No, thank you so much. Thank you so much for your very enlightening interventions. And I believe, to answer to you, that we can do both. And that's also what we're trying to do as MEPs. Each time we have the chance to improve the legislation, we push for it. And we are also, promoting and complete other visions. And of course, we begin by promoting values that are different. So we kind of are able to agree on all of this. So thank you so much again, really, for being with us tonight, to all the speakers and also to all the participants. We were again a few hundreds tonight, and it's really good to see that we can gather so many people on the idea of the rights of nature and on looking forward on how to implement them in real life, if we manage to do so at some point, but which I believe we can definitely do. Just to remind you that this conference will be available online in French and in English. In English first, but we have to download it and then put it online again in French. If you had sent some questions that we haven't dealt with to everyone or to some of the precise speakers, we will also ensure that they got them and that we answer them in the coming weeks, maybe, to give us a bit of time before we go on. So this was only the second conference. We'll hold 6 before the end of the year, where we hope to be able to present something quite more precise and concrete on what could be the way to the recognition of the rights of nature in Europe. I also remind you that there was a big study published on the website of the European Social and Environmental Committee yesterday, which is available in English and in French. And next time, in January this time, on the 12th of January, we'll hold a discussion on an issue that we also talked about tonight, but a bit more quickly. Is natural rights an extension of human rights? Question mark. And we'll welcome for this conference the Special Rapporteur of the United Nations on Environment and Human Rights, David Boyd, whom we're really looking forward to get with us. We'll also have with us Valentin Punt from the Earth Flow Center and other speakers yet to be announced, but we'll be happy to meet you again. And in the meantime, we hope to get back to you also with tools for participation and discussions on what could be the rights of nature in the EU. So thank you again very much. Thank you, Jessica Van Houten. Thank you, Laurent Fonbaustier. Thank you, Felipe, Calderon, and Valencia. And thank you, Kaarel, Relve. It was really good to have you with us tonight. And I say goodbye to the spectators, and I will stay here with the speakers and also the interpreters, whom I forgot to thank, and they're really important. So thank you also a lot for the interpreters who are here tonight and accompanying us in this conference. So see you later, everyone.
Bye bye to you all.
And let's keep fighting. Ciao. Thank you to the Nigerian rivers also.